Yeah, I'm now joined by Mpumelelo Zikalala, who I think, Mr. Zikalala, I'd want to touch a bit on, this issue of perhaps, or maybe a non-issue of the judge making, considering the possible application. So, the handing down of the reconsideration application, and two, what recourse may be taken or may not be taken as a result of that reconsideration application. Is this something that is the norm, or is this us seeing Judge Pitkun really trying to avoid any further delays going forward and really seeing the start of this trial?
He was really being proactive. He wanted to say, I want to be realistic in terms of this matter. I don't want to put in dates that I know that the parties are not going to be able to achieve, like 2 days. You can technically call it a wasted day because nothing really happened. So he was simply saying, I want to make sure that when you come back here, we're able to hear evidence. I want to make sure that I cover all eventualities. On a technical basis, two issues. The first, Section 35 rights, as you saw, that he was lamenting that I need to protect the accused in this matter, not even the second accused must be protected, so that the trial must start and end within the shortest amount of time. Secondly, the Criminal Procedure Act directs me as to what to do in terms of eliminating unreasonable delays. And this part of finding out what is causing these blockages, it is part of my duties, and I need to make sure that I am able to put in measures to make sure that at the end of the day, we don't come to court and have a day which is similar to today's one. Although indirectly, I felt a bit he was throwing the ball into the court of the SCA and saying, I do not understand why this matter has not been decided up until today. I would have expected, as it has been usual practice, that you are quite efficient. I don't understand why this particular matter has not been decided up until now. However, it's not my prerogative to decide that or to rule on that. There is the president of the SCA which is going to take that decision. But we certainly hope that by the time we come back on the 1st of August, everything would have been completed.
And we also would have heard then from Judge Pitkun saying that he doesn't necessarily believe that this reconsideration application is of substance. However, it's not in his prerogative to also make such a determination. And let's then remind the viewer of what the nature or what needs to be considered during a reconsideration application, considering that it's also taken so long just to be handed down. What is it that could have been, needs to be thought of, the factors that need to be weighed up in this matter?
It is basically looking at the nature of the application and saying, are the chances of this application succeeding? If there are no chances at all, should I at least give them an audience and say to them, I want to hear your submissions? But linked to that is the application, or the nature of the application which was submitted by the former president, in which the legal reps were saying, the Constitution guarantees us the right of access to a court. It does not only mean that we're able to step into a court to use those legal processes. It means that whenever there's a dispute which is taking place, we must be able to come in and make oral submissions. In this case, we haven't been given an opportunity to do so at the SCA, and we've only received a one-liner, as the spokesperson have said a number of times, in terms of a response. We are not happy in terms of we are not happy that we've been given an opportunity to make our submissions. All that we require from their side is we must go to court, make our submissions, be able to interrogate what the judges think of our submissions and the nature of our submissions, be able to further explain certain things which may not have been carefully explained on paper. Only then, after you've listened to us properly and comprehensively, you can then come back and dismiss us, or either say you uphold our application. To simply dismiss us on paper and say that your matter has no merit is something which is not unfair. Is unfair, and that is what they are saying on their side.
All right, there you have it, Hugo. That's Mpumelelo Zikalala just weighing in there, giving us the legal perspective then when it comes to this matter. And basically, as we've been saying throughout the morning, we are at the mercy, rather, of the Supreme Court of Appeal insofar as this trial being able to go ahead. The 1st of August is the holding date, but I can tell you that there has also been consideration given to, if everything is sorted by the 1st 1st of August. When I say everything is sorted, I mean that reconsideration application and any other possible applications being brought, and that it will be back here on the 1st of August, where it's likely then that another 2 weeks will be allocated for the state and the defense to organize themselves. The 15th of August 2022 until the 16th of September have been set aside for the start of the trial. Then it will resume again from the 7th of November to the 2nd of December 2022. But again, this is all on the basis of possible eventualities, and in the coming weeks and months, one will have to monitor then what happens in the country's courts.